Welcome to the Roetzel Health Law Hotspot. Health Law Hotspot is a podcast for physicians and health professionals that covers the legal issues and trends that affect the healthcare industry.
Hi, everyone. This is Ericka Adler. Welcome to the Health Law Hotspot. I'm a Roetzel shareholder and leader of our healthcare practice, and I'm joined by Christina Kuta, who's part of our health law group as well. Today, we're talking about a really urgent and important topic related to the FTC Restrictive Covenant Rule, which is supposed to take effect within the next 30 days. And we have been expecting that it was going to be delayed or stayed completely or terminated or canceled or something, but we're getting awfully close and nothing has happened yet. So we want to talk about what's going on, what employers should do to prepare, and what we might expect. So welcome to Christina. Give us the lowdown.
Thanks, Ericka. So if you saw our prior podcast, we talked about this FTC rule in some depth. So let's go over it just a little bit again so we all know what we're talking about. The rule prohibits on a national level all non-competition, generally mild restrictions, across the US with no exceptions for any employment or contractor arrangement. So what that means is any future non-competition provisions or any past non-competition provisions, with one exception we'll get to, would no longer be able to be in effect, even if state law otherwise allowed it. For non-competitions entered into prior to the date the law is supposed to go into effect, which is September 4th, but we'll discuss some of the issues surrounding that as well, there's some grandfather provisions. So non-competes that went into effect already for senior executives, meaning people who make at least $151,164 annually, and also make policy decisions for the business, those can be grandfathered in, but only if they've been entered into effect prior to September 4th, 2024. Now, one thing to keep in mind is these FTC rule does not impact non-solicitation provisions, non-interference provisions, non-disclosure provisions, or non-disparagement covenants. None of those are an issue. So if you're an employer and you have an agreement with your employees that says they won't solicit their patients when they leave your employment or your vendors, those are untouched. It's just the mild restrictions where you say, you won't set up another office within 10 miles, for example, of where you provided services for the employer. Now, I say that it's supposed to go into effect September 4th of this year. However, once the rule was made, there were a number of legal challenges, and there currently are several pending legal challenges all across the nation. Many of them have been appealed for various reasons and are different statuses at this point. However, there's one particular case in Texas where the judge has already stayed enforcement of this law for the parties to that particular case. So plaintiff and defendant in that case, the law is stayed and will not go into effect as applied to them as of September 4th. This judge, however, said he wanted more time to determine if he should stay in the effective date of the law beyond September 4th for the nation, meaning all employees in this country, all employers in this country. And he said he would rule on that on or before August 30th of this year. So we're kind of waiting on this decision to determine if this Texas judge on August 30th is going to come back and say, you know what, this stay should be implemented nationwide, and I'm creating an order that says that this law cannot go into effect September 4th. If that happens, and many people expect that might be what happens, but we don't know. If that does happen, it's likely going to be challenged legally by the government, and there'll be continued appeals, and the other cases across the nation will go through their processes. And eventually, I think it's probably reasonable to assume this is going to go to the Supreme Court. That's likely going to make the ultimate decision, perhaps in its term next year. So we're in a little bit of limbo now, but we need to prepare as employers. If the law does go into effect September 4th, there are requirements that employers must undertake prior to them. So you should be preparing now, just in case there is no stay and the law is going to take effect.
Okay, great. So I know also there's a little bit of a possibility that one of the legal arguments here has to do with the recent Supreme Court decision as well. And also that the outcome could be greatly impacted by where we're headed with elections. So let's talk about what your thoughts are on that.
Sure. So this term, the Supreme Court came down in a decision that impacted a prior decision, which was known as the Chevron decision. And anyone who went to law school knows you spend several days on the Chevron cases. And Chevron essentially said that courts need to give deference to different government departments on their interpretation of laws and their ability to make rules related to those laws. This current Supreme Court essentially overturned Chevron, and there's no longer that automatic deference. So a few of the cases now going through the court systems related to this FTC rule basically say, hey, based on the Supreme Court decision this summer, the FTC, Federal Trade Commission, did not have the authority to make this law, and it's outside the scope of what they're allowed to do, and courts don't have to give deference to that now. So courts need to look at exactly what happened and determine whether or not the FTC had the authority to do this rule. Prior to the Supreme Court opinion this summer, it's unlikely there would have been those challenges, or at least this number of challenges, under that prior Chevron doctrine. So that's sort of the first component. The second issue with the elections is we don't know who's going to wind up winning the presidential election this year, but there's some thoughts that if one person wins over another person, there may be more impetus for the government to fight back and want to have this law implemented as soon as possible, or for the government under that administration to say, you know what, we're not going to fight back, we'll let it go, we're not going to have the FTC law in place, we'll just pull it. And if that happens, then there would be no restrictions on a nationwide level for non-competes, although there still would be the state-specific limitations.
Okay. And Christina's being very politically correct, but this rule was put out under the Biden administration, Democrats. So it's likely that if they stay in power, they would want to fight for this to be enforced. You know, they made it a primary issue, of their agenda while in office. It's likely if the Republicans took office that they would just say, yeah, we're not fighting. We don't want this in the first place. So that's kind of what we could expect. So there's a lot of moving parts here, but most importantly, we're coming up that this will come out, mid-August, obviously. We're very close to that September 4th deadline. So I've been getting any number of emails and phone calls from various clients saying, well, what should we be doing? And it's really tough because we don't know. And unfortunately, we may not know anything until August 30th or even beyond. So what should employers be thinking about at this point? What should they be doing to prepare, if anything?
Sure. So, yeah, like you said, we're in flux, but there's things you probably should do as an employer now to make sure you're in compliance with the law if it does go into effect September 4th. And your main requirement is you cannot provide, I guess there's two things. One is you have to provide notice to all your employees that have restrictive covenants, that as of the date the law is effective, those restrictive covenants will no longer be enforceable and they're not subject to those restrictions. There's a template notice out there that the FTC put out, but I caution employers to use that notice because we don't want to say as of September 4th, because this could be stayed. It may not go into effect September 4th. So you want to make sure the notice specifically says, unless or until this law actually goes into effect, your restrictions are in place. But when the law goes into effect, if that occurs, then the non-compete will no longer be enforceable and you won't be subject to it. That's sort of one thing. I also would make sure that the notice is clear, that it doesn't apply to non-solicitations, non-interference, non-disclosure, or non-disparagement, and doesn't impact any other state laws or requirements. So, and those are things that were not in the template FTC notice. So it would be helpful if you consulted legal counsel to sort of craft a notice for you that adds those elements and works for your practice. The other issue is you're not supposed to add these non-competition restrictions into agreements after the effective date of this law. So let's say the law gets stayed or, we're in flux, we don't know what's happening with this law, and you want to have an employee start their employment after September 4th. So one of the things I would recommend is that, you can maybe add the language to the employment agreement, but make it very clear with the disclaimer that it is not otherwise effective when the law goes into effect. Make sure it otherwise meets any state legal requirements, so there's no state enforcement issues. I mean, you want to make sure you're in compliance with the restrictions if the restrictions are fully effective. So I think there's some good disclaimer language you can put in those agreements. The concern is if you say, look, I'm not going to put any restrictive covenants in any mile restrictions in my employment agreements until we figure out exactly what's going on with this law. The risk you run is, let's say 3 months from now, we realize it's not going to be implemented, it's dead. Okay. Now you want to amend your employment agreement, you have to go back to your employee and try to get them to agree to add a restrictive covenant in now, which most employees are going to say no. In a lot of states, and even just contract legal principles, you have to give some additional consideration to something of value, which is usually money, for that restrictive covenant to be enforceable if you add it to an employment agreement later as an amendment. So I think better to add it now with language that makes it clear that it's not effective and it's completely, void in the event this law goes into effect. And also add some what we call severability language that makes it clear that just because one part of your employment agreement isn't going to be legally enforceable doesn't mean that the other parts aren't legally enforceable. I think those are things to consider now to prepare and to be as prepared as possible based on the fact that this is just in a transition and we don't have any good concrete answers right now.
Right. And I think you and I talked about this in our last podcast in depth, which is if you don't have the non-solicitation, the non-interference, the confidentiality and non-disclosure, you should, right? No employer should be relying just on a geographic restriction, even if they are allowed, right? So you also want to go back, take a look at your language and make sure that it is as thorough and complete as it can be. So it's a good time to do that. I know that we're going to be sending out these notices with instructions to our clients in advance to be prepared just in case. We recommend that anybody listening to this who has not heard from their counsel on this topic, reach out either to us or to your lawyers to craft an appropriate notice based on your own contracts and what works for you. Can you tell me, did the law speak at all to what would happen if employers fail to provide a notice to their employees? Is there any kind of consequence?
I believe there are some penalties. Unfortunately, off the top of my head, I can't recall what they are, but there are some enforcement mechanisms that the government can take if employers are not complying with the law, which is why I don't wait to see what happens August 30th. Particularly because judges may say August 30th, but they control their own order schedule. So if the judge decides I need more information or I'm not sure yet, he could wait until September 7th to make a ruling. So you don't want to really wait up until that line because if there is no national stay, and currently there is none, this is going to affect September 4th.
Right. All right. Well, this is really big news, urgent, or it could just disappear and be a non-issue. We're not sure. We want to make sure everybody understands what's going on and that employers are taking the action necessary to make sure that they're protecting themselves in advance. Any final thoughts?
Just again, don't wait till last minute and make sure you craft that notice to meet the legal requirements of the FTC rule, but also protect yourself in the event there is a stay and it's not actually going into effect on September 4th.
All right, perfect. Well, thank you, Christina, as always. This has been the Health Law Hotspot. You can reach out to either Christina or myself with any questions, and please be sure to check out our other podcasts at ralaw.com, and we'll see you next time. Thanks for joining us.
The Roetzel Health Law Hotspot is made available by the firm and its attorneys for educational purposes and to provide general information, not to provide specific legal advice. Use of the Roetzel Health Law Hotspot does not create an attorney-client relationship between you and the firm or any of its attorneys. The Roetzel Health Law Hotspot should not be used as a substitute for competent legal advice, and you should contact an attorney in your state about any legal needs or questions you may have.